I think we're now in a good place to start. Thank you for joining us for this webinar, which is designed to assist schools and colleges to deal with the exam grading confusion and the potential challenges that lie ahead. To do some introductions, my name is Ben Lear. I am a Director and Head of Education here at Hayes Parsons Insurance Brokers, and we've teamed up with DACB Beechcroft Solicitors and 3PB Chambers to deliver this webinar to try and help you through this. We've got Becky Lee, who is a Senior Associate, and Kylie Poynier, who's a Legal Director from DAC Beechcroft, and Matthew Ward and Lachlan Wilson from 3BB Barristers. We have received some questions in advance, but should you wish to ask any during this webinar, please just click on the Q&A icon and it will come to me to ask our panelists at the end. The intention is to last about 30 minutes plus questions, and hopefully we will achieve this, although we have had to rewrite part of the content in light of recent DFE updates. However, the webinar will be recorded and copies will be provided should you miss anything or wish to pass on to any colleagues within your organisations. I will now pass to Kylie from DAC Beechcroft to take us to the next stage.
Thanks, Ben, and thanks for hosting today. As Ben said, I'm Kylie Poynier, a Legal Director in our Professional and Commercial Risk team here at DACB. I head up our education service line, which involves us acting for independent schools, colleges and universities and their insurers in respect of failure to educate and discrimination claims. I do appreciate the time you're taking out today. It's obviously precious time at the moment, and that pressure on you is only going to increase with the publication of GCSE results on Thursday. I think teachers, students and parents alike are having to deal with the stress from the mayhem surrounding exam results in what were already difficult times. Despite them having since March, the numerous U-turns taken by the government and Ofqual has effectively seen them driving around in circles. That said, I do think we've potentially reached a landing that should be welcomed, but is it too late? And what of those university places that have already been offered elsewhere? Becky will touch on that shortly. We've already started to see claims from disgruntled parents for fee refunds as a result of lockdown, and I think such claims are only set to increase. Unfortunately, they're quite difficult claims to deal with, particularly if parents are acting as litigants in person, given the emotions involved. In addition, we're increasingly seeing subject access requests being used as a tool in this litigation, and that is obviously something that will place a significant administrative burden on schools and colleges. The purpose of today is to highlight the current guidance, as Ben says, as at 4 p.m. yesterday, for appeals and the grounds available, and we'll also look at the issue of subject access requests and how best to deal with them. Please do make use of the Q&A session at the end, but in the meantime, I'll pass you over to Becky.
Thanks, Kylie. In a minute, Lachlan and Matthew will discuss in detail the impact on schools as they digest the U-turn by the government on predicted grades last night and the issues and challenges that this is likely to throw up for schools. Before they do, I just want to touch briefly on the issues and impacts on the universities with the ongoing confusion caused by the standardisation model and the delay in reverting back to the predicted grades, or the centre assessed grades as they're known. Following receipt of their results last week and the downgrading of up to 40% of grades, many prospective students will have reassessed their options already and either opted to take their second choice at a university or take up another course, possibly at another university, through the clearing process. The delay in the government's decision to revert to centre assessed grades will cause significant challenges. Universities have already begun the clearing process and offered places to students that would otherwise have been taken up by students who had originally had their grades downgraded by the now infamous algorithm. We are hearing reports this morning that some universities have even completed their clearing process and course places are therefore already full. However, those students whose grades have now increased are likely to revert to their first choice universities to seek confirmation that they are now able to take up the places that they had originally been offered. This will of course cause a significant headaches for universities in the coming days. The Chief Executive of Universities UK has already warned universities that they should be flexible as they can in helping students find a place, but has also warned that, and I quote, "Today's policy change will mean that more students will have the grades that match the offer of their first choice university. This will cause challenges at this late stage in the admissions process: capacity, staffing, placement and facilities, particularly with the social distance measures in place. Universities will do everything they can to work through these issues in the days ahead. The Education Secretary, Gavin Williamson, has spoken this morning of putting together a task force to help universities, but it is yet to be seen how this will assist and work in practice. Our university clients have also shown concern already that they may have lost out on their best candidates due to the predicted grade system and the delay in the government's U-turn. They are also struggling to begin timetabling, with it being unclear what and how many students will be attending, and with their resources already being stretched due to the furloughing of some staff during the pandemic. There have been calls in some quarters for universities to halt the clearing process at this stage in order that grades can be confirmed first. However, this process, as I've already said, has been completed in some areas, so course places have now been taken and accommodation has also been taken up. A numbers cap had been introduced by the government in a bid to prevent damaging competition among universities that were struggling to recruit domestic students to fill gaps left by international students that had been put off from travelling to the UK because of the pandemic. Universities in England had only been allowed to recruit 5% more UK students than their targets this year to prevent competition and over-recruitment by some institutions at the expense of others. Whilst this numbers cap has now been lifted in a bid to help universities offer places to students, admissions offices have been reporting better than expected interest from international students. This will only mean a further squeeze on places. As a result, some students may also decide to defer going to university until next year, which may affect the level of capacity for those students now in year 12 who are then hoping to take up a place next year. This has, of course, come at a time when universities are already struggling to deal with complaints that have arisen from existing students coming out of the pandemic around distance learning and tuition and the perceived lack of value for money. We have published an article on our website if this is of any interest, and I can provide the link after this webinar. But for now, I will pass you over to Lachlan and Matthew.
Yes, thank you very much, Becky. Morning, everyone, and thank you for spending the time today to listen to us talk. I'm going to talk to you for about 10 minutes on what your information law obligations are. Ben, if we can go to the next slide, thank you. Now, with the first question, the key question for examination centres to ask themselves is, what information, if any, do we need to provide to our cohort? Now, the ICO, often fairly unclear on these things, actually has been really helpful in this instance, and it has specified exactly what examination centres should be disclosing. You can see from the slides I've listed for you the 5 key things. So you've got the centre assessment grades, the rank order placements, the candidate teacher assessments, any written comments made on any of those, and a record of their past academic performance. Now, we saw yesterday the government's complete U-turn in relation to how A-levels and GCSEs are going to be marked. And in my view, bearing in mind that they're now going to be based almost entirely on teacher assessments, it's absolutely imperative that students, if they're going to be challenging these grades, get this information. And therefore it's far more likely, therefore, that as independent schools, you'll be receiving requests from students for this information. Hence why it's important for you to understand what information can be provided. At the same time, it's important to understand what you don't have to provide. And the caveat here for what you don't have to provide is any information that candidates have recorded themselves, or of course, information about one candidate to another. So that's what you have to provide and what you don't have to provide. The next question then is, how should it be provided? Ben, if we can go to the next slide. In my view, there are 2 ways for information to be provided. Firstly, voluntary disclosure. Now, I don't know about all of your schools, but certainly some of the ones that I've spoken to in the last few days provided centre assessment grades to their pupils alongside their A-level results. Now, there are one of 2 ways you can approach that. It's either a positive, in that all of your student body knows exactly where they stand, but on the other side of the matter, for schools, it could mean that people are potentially more likely to appeal than not if they were likely to be happy with their results, but then based on the information you've provided, it then makes them unhappy. Ultimately, there's nothing we can do about that now if you have voluntarily disclosed information to pupils, but that was one way you could do it. Of course, what you need to think about as schools is your resource capacity and the amount of time that you want to take up dealing with potentially subject access requests, which is what I'll come on to discuss in a second. There is no reason, in my view, why you can't think ahead. And if you envisage being overwhelmed with all of these requests, there's absolutely no reason why you can't voluntarily disclose this information to your pupils. It could be a letter that goes around to all the students, or indeed an email, a template email that can be amended to include each student's individual information. So that's the voluntary disclosure. The second part is where you have to disclose information, and that is something that you're probably all familiar with, which is a subject access request. A letter comes in, may or may not say subject access request on it, but ultimately it seeks information that you know as a school is pupil information or data that you control, to use the term of the GDPR. You have 1 month from receipt of that request to provide the information, and insofar as the information you have to provide, that's the 5 key things on the previous slide. Now, if we can move forward, please, Ben. One unique problem that faces independent schools that probably is certainly unlikely to be faced in the maintained sector relates to the size of the schools. Obviously, in the maintained sector, you have class sizes of 30. The schools we all understand are much, much larger than independent schools. Now, this poses its own unique problem, particularly if you've got a particularly small cohort and where you're going to reveal information to one pupil, it could inadvertently reveal information about other pupils in their year. Now, the ICO, besides my point earlier about the ICO being helpful, the one caveat with the ICO is they haven't been helpful on this point. And I've been tracking through the ICO data for the last few days, and what's on the slide there is all that the ICO says on the point. So it appears from the ICO's guidance that it's going to be a matter for the school to decide whether it's reasonable to disclose information if they think doing so is inadvertently going to provide information about another pupil. What's reasonable? Well, lawyers have been arguing over the concept of reasonableness for years, so I don't think it's fair, really, from the ICO's perspective, to expect schools to completely be able to make this decision themselves. What they do provide is further guidance in the following paragraph that explains that you need to think about how fair it is to not provide this information to your smaller cohort when it's available to the other large cohorts in the country. Obviously, the first step is to try to get consent, because if you've got 5, 10, 15 students in a year, it's not really beyond the realms of possibility that they may all consent if they all want to get the information themselves. So that, in my view, would be the first step. Ask the students if they're happy for you to disclose information. It's when they refuse that you have issues, and that's when you need to consider whether it would be reasonable to disclose it. For what it's worth, my view is actually this is one of the things that would be worth taking advice on. We'll come on to freedom of information in a second, and it seems to me that whenever as a school you're likely to refuse to release information that arguably you are legally obliged to provide, it is something that's certainly worth taking advice on. If we can move forward, please, Ben. Alongside subject access requests, the other tool that we're probably all familiar with are Freedom of Information Act requests. I'll refer to them as FOIA requests. As we know, the first thing you need to work out when you get a letter that you suspect may be a FOIA request is whether it is in fact a FOIA request. Importantly, the letters do not have to stipulate on them, similarly with subject access requests, that they're freedom of information requests. So it means that as a school, you need to identify in advance whether or not it's likely to be information that you can disclose. You would have 20 working days to respond to such a request if you were to receive them. The second step is whether you can identify precisely what information is being sought. If you can't, obviously ask for clarification. Ben, if we can move forward, please. Now, obviously you're independent schools and therefore in many respects not considered a public body at all. The reason this is relevant to you is because of the next step, which is that there are some organisations that may potentially attempt to signpost people to you in relation to information that you may hold. So it's not beyond the realms of possibility that local authorities, etc., depending on the makeup of the children that go to your school, may potentially signpost parents to go to the school itself in order to get information. So you need to determine, if that happens, whether you actually hold the information that's being requested. If you don't, then you can say so. If you know who does hold it, then you also need to say so. If you do hold the information, then you need to collate that information and determine if you actually need to disclose anything. Now, there are a number of exemptions under FOIA. I'm not going to go through all of them because it's, in my view, highly unlikely that class-based or prejudice-based exemptions are going to apply. The only one, in my view, that may potentially apply is the public interest exemption. Again, if you're minded to withhold information under that exemption, definitely something worth taking legal advice on, because there's been a significant amount of litigation on what actually amounts to the public interest litigation, both in the civil courts and the Information Rights Tribunal. Ben, if we can move forward, please. So perhaps the main issue for independent schools is, what are the risks to us? What are the risks to our business in relation to our pupils' information rights? In my view, they are, in a nutshell, what's set out on the slide here. So the first risk is a complaint to the Information Commissioner's Office. Now, this would follow a subject access request. If you fail to respond, or you fail to provide information with timescales, you're potentially providing correct information, then obviously you're going to have fairly aggrieved candidates, and there is a risk that they may go to the ICO to try to get the ICO to require the school to rectify any deficiency. Now, in the first instance, a complaint to the ICO is not necessarily something to worry about, because certainly in my experience, in the first instance, the ICO will consider the complaint, write to the school with its provisional view, and if its provisional view is that the school should provide the information, it will ask the school to do so. 99% of the time, if that happens, that resolves the issue because the school complies. However, what can happen is the Information Commissioner's Office may agree with the school, and it may decide that you don't need to provide the information that's being requested. Now, a pupil's recourse in that situation is to go to the Information Rights Tribunal and challenge the decision of the ICO, and there is an equal risk that if that happens, the school could be brought into the litigation as an interested party. And I have seen times, not necessarily in the education sector, where the ICO is a defendant and the school is brought in, or another institution is brought in as an interested party, and the ICO effectively washes its hands of the situation and says, we'll deal with the other party. So that's a risk, and it's something you want to try to avoid. Similarly, there are civil litigation risks, and in my view, those risks are threefold. Lachlan will be discussing this in more detail in relation to negligence and breach of contract, so I won't deal with that fully now. The real risk, insofar as information is concerned, is a potential challenge for breach of confidence, and this would arise if you inadvertently provide one pupil's information to another pupil. So if you go back to what we were discussing earlier, where you're in a small school, if you effectively, by providing information, reveal another pupil's data, that could give rise to a breach of confidence claim. And in reality, there is a real risk that that could be successful, because on the one hand, in terms of breach of confidence, you have to show, if you're the claimant, there was a understanding that the information itself was confidential. And in my view, it's probably fairly arguable that pupils' examination results are confidential. You then have to show that the information was disclosed to another person outside of that confidence. And again, if you've actually sent a letter, then that's going to be fairly simple to evidence. So those are the risks. I said I was going to speak to you for 10 minutes. Those are my 10 minutes up. So Ben, if we can move on to the next slide, and I will hand you over to Lachlan Woodson.
Thank you for that, Matthew. And Ben, if we can actually move on to the next slide, we get to where I'm going to kick off. Because what I want to do now is just take stock as to see where we are in the light of the U-turns across the UK. Have a look at the appeals processes from the school's perspective, and and also from the student's perspective, and then finally, as you might expect a lawyer to do, focus on where litigation risks might lie. Next slide, please, Ben. So it is now the decline and fall of the algorithm. The algorithm is in disgrace, and we now go back to the centre assessed grades as far as the grades that are awarded. But the question now is to determine or to identify who has suffered out of that. Now, Becky has already talked on the first bullet point in the middle of this slide, the students who have been denied their university place based upon the abandoned downgraded results. And of course, what that might make you feel as independent schools is that there is now a shift in the administrative burden. Becky touched upon potential challenges that may be made either to the UCAS system or indeed to individual universities themselves, and of course also to the government to try and guarantee some of those places that are now no longer available, either by way of increased resources to the universities. So that's the first type of student, but I think the second type of student is the one where you're likely to get, as independent schools, the greatest challenge, and that's what I have perhaps loosely described as the lastminute.com student. Being one of those myself who cruised throughout the year, not necessarily paying attention to what my teachers were saying through the year, but fairly confident that come the exam stage, I would be able to not just wing it, but do that last minute revision. That student may consider that they have been badly done by the teacher assessed grades or the centre assessed grades. And it may be that that student is the one that is going to be the biggest challenge at this stage. Next slide, please, Ben. Just briefly, the student who's been wrongly denied a university place, of course, that's an issue that remains a matter as between the student and the university, and potentially through the UCAS's failure, but that would need to be, I would imagine, some kind of class action against UCAS for allowing the system to allocate places, even though even Ofqual was, even prior to the announcement of the results, showing signs of not showing confidence in its own algorithm. But that shouldn't concern you as independent school organisations, other than the fact that the institutions that these students are applying to may wish to write directly to you, particularly as there is doubt that going back to centre assessed grades and relying simply on centre assessed grades, there may not be inflation in those grades. So there may still be a dialogue to be had between the university institutions and the schools to give confirmation in each individual case as to whether the students' grades are to be trusted as to their abilities. So that may be something that will arise. And of course, anything that you put down on paper or say is something that might come back to bite at some future date, but you need to be careful about what it is that you are saying on behalf of the individual student, because of course, as Matthew has touched upon, that information is disclosable in any subject access request. All right, next slide, please, Ben. So what about the student who is disappointed with their grades? Now that may be, well, that can only now be because the student is disappointed with the centre assessed grade. What's the process? Well, I've headed this slide deliberately, who knows, because if you go onto the Ofqual site and if you go onto the government site, they're still sticking with the old guidance as if standardisation has been put in place. So watch this space, things may change. But consider the grounds of appeal that may have existed under the original review process, and indeed the original review process that was amended for 2020 to allow for standardisation. And they were where the institution made an administrative mistake, where the exam board had made an administrative mistake, or where the cohort's grades are lower than expected because of previous cohorts. Now that, of course, is not something now since 4 o'clock yesterday, that third ground is not something that you'd expect to be available in any new guidance that may or may not be issued in the coming days. But certainly the lastminute.com student may wish to seek a review of their final grades based upon the centre assessed grade. So what grounds do they have? Next slide, please, Ben. The student may wish, because of course the student will have to, in order to challenge its grounds, appeal to the exam board. But the student cannot do that themselves. They require you as the centre to take that appeal forward. If, and again, you would need to be careful about whether or not you would wish to take that forward, because of course you would be admitting that there was something wrong with your centre assessed grade. But if you wish to support it, so be it. But if you don't wish to support it, if you stand by the grade that the student has ultimately got as a result of the U-turn, you need to have a review mechanism in place when the student asks for an appeal and you don't support it. And that needs to be conducted by someone entirely independent from the person who decided the student couldn't appeal. All the circumstances need to be considered, and bear in mind that, again, in these uncertain days, the potential threat of a mandatory injunction in the event that you still, at appeal, refuse to support. But of course, all that will be governed on the particular circumstances, and the likelihood of that succeeding will be governed on those circumstances. Next slide, please, Ben. If you are going to support the student, you need to do the work because you will have principal access to the data. So, for example, if you realise you've made an administrative mistake, you've got to own up to it and prepare the evidence in that regard. The exam board having made a mistake is an unlikely ground in our circumstances now. It all lies on your shoulders and your assessed grades. Next slide, please, Ben. So what sort of advocacy would assist in support? Well, the initial analysis that you might have been required under the original regs might assist. You should prepare your evidence based upon the predicted grade marks, the actual grade marks, the class-based assessment grades, and how the student compared. But ultimately, if you are supporting the student in their appeal, you are pointing to something that you may have done wrong in your centre assessed grade. And of course, now it's no longer necessary to consider the performance of the previous year's cohorts. Next slide, please, Ben. Of course, the student, if you don't support, has the ability to complain about the malpractice that it will say the institution or its centre has created by giving a poor grade. Now, let's be absolutely clear. Malpractice is not the academic judgment involved in that a teacher necessarily involves itself in when giving a grade assessment. Challenging academic judgments are notoriously difficult by students. It will have to be some other form of malpractice that the student must point to determine why the centre assessed grade is the wrong one. The student must exhaust the school's internal complaints policy first, but then, and I say with some degree of certainty because it was the position prior to 4 p.m. yesterday, and I don't see any reason why it shouldn't be maintained, then has a route of complaint to the exam board, and the exam board can conduct its own investigation. Next slide, please, Ben. And under the original guidance, if the exam board thinks there's been malpractice or maladministration, the exam board will then consider whether the result is issued took that information into account were wrong, and if so, whether it should change those results. What that arguably does is de facto give an opportunity for students to appeal, even though we've said originally that students don't have the ability to take the appeal themselves. But there you are, that was under the original guidance. We shall have to wait to see if that is repeated in the fresh guidance once it is issued over the next couple of days. Next slide, please, Ben. So what are the litigation risks? And should we be concerned? Next slide, please, Ben. Negligence. For a student to show that the school had breached its duty of care and that breach caused them loss. In this scenario, it can only be that the school had breached its duty of care in giving it a grade that was lower than the grade that the student should have been entitled to. And without challenging academic judgment, it is a difficult hurdle for the student to establish. But as we all know in the litigation game, whether it's a difficult hurdle or not does not necessarily prevent the challenge from being made. It's right that if you as a school complied with the Ofqual's guidance at the time in how to administer centrally assessed grades, again, that is likely to help and assist in defeating the claim in negligence. And also there's causation questions. Yes, not in terms of the standardization process, because that of course has now gone, but whether or not the school's failings have actually caused the grade to be assessed at the grade it is a matter that will turn on its own facts. Next slide, please, Ben. Discrimination. There's a lot of talk about discrimination and the fact that certain schools and institutions may be seen to be discriminatory towards its students. The first step for considering it is the Freedom of Information Act request that Matthew has touched upon that the student will bring. And you should approach any request for information of those protected characteristics with caution. But of course, you are obliged to give up information concerning, anonymized, obviously, the protected characteristics and how your grades have been assessed. So you should do that, but approach with caution. I do not believe any institution will say on the face of it that yes, it has been discriminatory in the way in which it has awarded its assessed grades. But of course, if the statistics show differently, that may give rise to a question and to a reversal of the burden of proof in showing it. Next slide, please. Again, if you have complied with Ofqual's guidance as it was at the time in which the assessed grade was created, it may be that you can defeat a discrimination claim. But what you will hopefully have done is have kept accurate recordings of the rankings and the assessed grade awards that you've given, and the reasons that each pupil was given their particular placing and their particular award. Next slide, please, Ben. Contract. You're independent schools. You are governed by contract, not between the student and the school normally. Normally between the student's parents and the school, but where A contracts with B for the benefit of C. Equally, if C does not achieve sufficient benefits, arguably it is a breach of contract. Where's the potential for breach of contract? Well, what about failure to use reasonable care and skill in calculating the assessed grades and in ranking the student concerned? Failure to use reasonable care and skill in not submitting an appeal on behalf of a student in circumstances where it may be challengeable that the centre assessed grade is not right. Failure to use reasonable care and skill in failing to have in place an adequate appeal or review system. So in other words, failure to provide the adequate appeal review system in the circumstances where you have refused to support a student's appeal. And failing to find in favour of a candidate in that way. Next slide, please, Ben. One other matter that may or may not be relevant is whether or not you've got a force majeure clause in your contract. Again, whether that is relevant will turn very much on the nature of the challenge, why it is the student is saying that the assessed grades are lower than they should be. And if to what or to any extent that may be attributable to pandemic, maybe. Again, that's not something that is wholly determinative, unless, of course, the particular circumstance of the case suggests it. And finally, that last comment is really just regulatory oversight. If you've complied with your regulatory oversight at the time in which you've provided the centre assessed grades, you should assist yourself in defeating any challenges. Thank you, Dan.
Thank you to all our expert contributors. I think on the last couple of slides, it might be worth linking it to the insurance protection, which is in force. So schools and colleges will have professional indemnity insurance, whereby if there's allegations of breach of contract or negligence, as has been touched upon, which has resulted in suffering by the claimant, then the remedy, the right of recourse, is to basically sue the school or college. The issue I think we need to consider is here, ordinarily, the school or college needs to exhaust its three-tier complaints process. The insurers may well keep a watching brief when it hits the third tier, but at that point, there is no insurable claim. There is at the moment a circumstance which may give rise to a claim. We also have to consider claims reporting conditions where you need to speak to your insurers when you know of a circumstance that could reasonably give rise to a claim, which basically dovetails with what I have just said. We've also got to consider the timescales involved here, because this is a very fast-moving process, as the last 3 or 4 working days have proven. Actually, let's include the weekend, because we had a U-turn over the weekend as well. And to be honest with you, nobody's set up to deal with these, because we're in uncharted waters. To my knowledge, there is no legal precedent that people can hang their hat on. So we're going to need a few test cases potentially. But also, because you need to exhaust the complaints process, that might not be done in time for the pupil in question to get the desired outcome for the new academic year. So, and also they have a few years to bring a claim as well. So if you have been lucky enough to not have any challenges, that may not stop challenges being brought further down the line potentially as the dust settles. So I think for those that are on the call, it may be worth considering what conversations you're having internally, making sure that those in complaints and compliance are speaking with those that look after the insurance side, so it's the left arm and the right arm are talking to each other, and you are having those conversations with your insurance brokers. The reality is the insurers themselves will probably rely on their panel insurers to provide certain guidance when it trips past the complaints process, which is where the likes of the ACB would probably come into their own. But I think communication is key, because you don't want to unwittingly prejudice the insurance protection by not having that open communication. So, which leads on to any questions that there might be. And we've had a few, so I'm just going to ask them, and it would be good if the panel, whoever is appropriate, could perhaps respond. So these are obviously anonymised. As we are not fully appraised of the process used by the exam boards to standardise exam results, how can we know whether they have followed their procedures when they review results? It seems likely that they are simply marking their own homework.
Well, I think the answer to that is yes, albeit now the standardization process is less relevant to what might be the ground of appeal. Nevertheless, the question, what founds the question, is a fundamental loss of trust as to whether an appeal might be undertaken competently. And that's an understandable question, but of course it's less relevant now, because of course the standardization process has been abandoned.
Thank you, Lachlan. The CIE has a post-results check and then an appeal process. They're unsure about the difference between the two. Does anybody have experience on the panel in respect of the CIE? If not, we can always revert with an answer on that particular one.
We come back on, Ben, actually, that would be one that we can follow up on.
That's fine, because that's quite precise in respect of the Cambridge International. I'm not sure whether this one's relevant, but in respect of exams getting cancelled in October or November as a result of potentially a second wave of COVID and what the implications of that might entail?
I think, Ben, the answer is that simply no one knows. Hopefully the exams won't get cancelled, I think is the starting point. The reality, I mean, as we all can see from how slapdash Ofqual have been in terms of how piecemeal they've given out their guidance, we're honest, no one's going to know until nearer the time.
And I think, given the chaos that's ensued in this time, I think preparations will be made as far as can to try and make sure those exams do go ahead, as that's obviously the best way to avoid the confusion that's happened this time.
Thank you, Becky. If the appeal process makes it compulsory to reconsider candidates who are happy with their grades, is this fair? Is it creating conflicts between students?
Sorry, Ben, can you repeat that question? If the appeal process...
If the appeal process makes it compulsory to reconsider candidates who are happy with their grades, is this fair?
It won't, or at least it won't give the process the ability to retract candidates who are happy with their grades, unless that candidate is the person who is appealing. But the person who is appealing is unlikely to be appealing if they're happy with their grades. I see maybe that question also may be predicated upon a belief that if an individual's grade is raised, somebody else's grade must be reduced. That isn't possible in the appeal process. So that shouldn't happen. There's a political question to be had about the confidence that is to be placed in the whole grades awarding process, and whether or not, as a result of COVID and or the fiasco in dealing with the system, we won't have a massive increase in number of higher grades. And so that kind of fluctuation, but that's a different issue to what actually can be achieved on the appeal process.
Okay.
I think Lachlan, that's absolutely, sorry Ben, I think that's absolutely right, Lachlan. I think potentially the author of the question as well, it may have been written before, I don't know when it was received, but before yesterday's announcement, because I know there was some concern, certainly amongst the maintained sector, about whether or not the appeals process was actually going to require potentially the rank order to be changed as well, which then in turn would have meant that other people's grades could potentially have been affected. So I suspect that's where the questions come from, but otherwise I think Lachlan, that's absolutely right.
Thank you both. Mocks. I'm not sure how relevant the mocks are in relation to the recent DFE updates, but what if the school did not run any mocks because of the outbreak?
Interesting point, in which case it couldn't have applied the process of having a mock result in its assessed grade that it provided to the exam board. Then the school would have had its own, taken its own factors into consideration for the assessed grade, notwithstanding there was no mock grade. It must have done it, presumably, on coursework undertaken prior to the pandemic, and perhaps previous examination record of the students in question. If it can show that it's done that, then the grade, such as it is, the now awarded grade, will have sufficient robustness to stand scrutiny. Where it may become a problem is if the student says the centre assessed grade is low. And then the question then is, the school must bring into the foreground precisely what information it did take into account, bearing in mind there wasn't a mock grade, what information it did take into account before providing the centre assessed grade. And ultimately, again, the likelihood of the school resisting challenge in those circumstances will depend on how it answers that question.
Okay, thank you. We've got 3 questions related to one theme and 1 additional question, just to gauge what's in the question bank. And the theme, if you like, relates to the documentation and presentation in respect of how the information is going to be provided. I don't know whether we know the answers to these, but the first one is, do we know what template should be used if schools are to print their own documents containing the teacher assessed grades?
I can give you some idea because I've seen one, and it was literally, it was in the maintained sector. All they did, so students obviously get their little brown envelope that I'm sure you all remember getting a few years ago with their A-level results in. What they did in this circumstance is there was another page in there. It was on the school's headed paper, and it was really simple. It just said your centre assessment grade is X, your ranking place was X out of however many students, and it just gave that to all of its pupils. Insofar as subject access request responses go, and actually it's probably worth clarifying this point because I mentioned Freedom of Information Act requests within my talk. Obviously, de facto, on a preliminary review, independent schools doesn't apply the Freedom of Information Act to it because they're a private institution. Freedom of Information requests come into it if you end up getting a request signposted onto you from another body. But if you do need to deal with one, then the ICO has pretty straightforward precedents, or I've got no doubt that Becky or Kylie would be able to point you in the right direction as well.
Okay, thank you. Will a certificate be generated by the exam board, and will it show teacher grades or the generated grades or both?
Oh, that's a good question. I'm not sure we know that yet. I guess hopefully that will be clarified in the coming days.
Which is linked. Sorry, go on.
I suspect, to give faith to the government's announcement, it will be the exam board's grade, and the exam board will adopt the assessment grade, the centre assessed grade, but it will be the exam board's grading.
Right, okay, if that takes care of the third aspect. The final question, if a student did well in their mocks, but other evidence suggested that this was an atypical result and they were assessed to have a lower grade, what evidence would you expect to see to support the assessed grade?
This is a very sad question. I had read it before because it had come up. So what that means is the school is pitted against the student, notwithstanding how well he did or she did in the mocks, in order to show that the student isn't that clever. It's a very sad question because that's the issue that the student would naturally challenge. I could have done similarly in the final exam had pandemic not have occurred, and I've been given the opportunity to do so. But if the centre is standing by the grade that they have provided for the student, then the sort of evidence you'd expect to see is evidence of the student's progress over the year, perhaps previous examination results, and it's something that I would expect to see, if I were judging that situation, I would expect to see an explanation as to why the mock result was considered to be an outlier or atypical. And that might be because of a cock up in the teaching, and in fact the mock questions had been taught only 2 or 3 weeks prior, and so were therefore very fresh in the student's mind. But you would expect to see why it is contended on behalf of the centre that the mock result was atypical.
Thank you.
If I can follow up on that very briefly, Ben, the other point, of course, is that when schools were submitting their information to the exam boards, if schools were relying on mock grades, what schools had to do, as I understand it, was basically declare that the mock grade was done. The mock grade came from a mock exam that was done in exam conditions and was marked using effectively the examination board's marking criteria. So there's another question that arises in my mind, is why did the pupil get such a high grade? Was it because of their ability, in which case there's a question mark over why you would then want to have that reduced? Or was it because the school didn't mark it in line with the criteria and therefore potentially marked the student higher than they should have done, in which case there's a massive risk for the school and it may potentially undermine all of their submissions to the exam board?
Okay, that's very helpful. So that concludes today's webinar. I'd like to thank the attendees on the call, but also the participants, being Becky and Kylie from DAC Beechcroft and Matthew and Lachlan from 3PB. Contact details are on the screen. If you wish to follow up with anything, you can contact them directly. And as I say, this webinar will be emailed out shortly, and you can distribute it towards relevant colleagues within your organisation. Thank you all for attending. Goodbye.
Thank you.
Thanks,
Thank
Ben.
you.